Good morning all. Yesterday's class we started with making of the constitution. So in making of the constitution, just we had introduction. The first person is 1934 M.N. Roy. He is the person who is responsible for the demand for a constituent assembly so that a new constitution can be made. Then Indian National Congress, then Nehru, then August Offer, then Cripps Mission, then Cabinet Mission Plan. Then the Constituent Assembly came into existence in 1946. Then the total strength, British Indian strength, we discussed about this. Working of the objective resolution. Objective resolution. Constituent Assembly has declared. Constituent Assembly has declared that India would be an. So Constituent Assembly is nothing but an assembly which is constituted for the sake of making of the constitution is called as Constituent Assembly. So this Constituent Assembly declared that India would be an independent, sovereign republic, and to draw a constitution for future governance. Independent. Independent means no country is controlling my country is called as independent. Independent means no external country controlling internal country or our country is called as independent. Or if I take from individual point of view, no one is controlling me, independent, and I am having the power to determine my own policies without the influence of external is called as sovereignty. Independent means just I am uncontrolled is called as independent. I am uncontrolled is called as independent. Sovereignty means in the process of making policies, I am not influenced by any external factors is called as sovereignty. The terms are very important. And republic, head of the state is elected. When the head of the state is elected, it is called as republic. Head of the state is elected as well as the head of the state is citizen of the country. Two conditions. Head of the state is elected as well as the head of the state is also citizen, then we will be calling it as dominion. Head of the state is foreign person, then it is called as dominion. India shall be the union of state, it is not a federation of states. America is federation of state, India is union of states. Lot of meaning is there. India is a union of state but not a federation of state means Indian union is not an understanding. Indian union is not an agreement. Indian union itself a natural system. Indian union itself is a natural combination without any agreement, without any memorandum of understanding. Why? Because in United States of America the 50 states are MOU. The 50 states are agreement. So whenever there is agreement between the states, it is called as federation. Whenever there is an agreement between the states, it is called as federation. When the natural combination, it is called as union. Without any conditions, without any memorandum of understanding, without any agreement clauses is called as union of states. We combined naturally, we combined organically, without any agreement is called as union of states. Federation of states, we combined, we integrated because of conditions, agreements is called as federation. India is not a federation of states, India is a union of states, organic. India is an organic nation. So we are great when compared to United States of America. You are 50 states because you are an agreement. We are not an agreement. We are organically formed together. We are together. So union of states. These all are present where? These all are present in the objective resolutions in the Constituent Assembly. Means for the first time when the Constituent Assembly came into existence. So how our India should be, how our nation should look like. So they came up with the objective resolution, means targeted. Objectives means targeted resolutions. In that targeted resolution, they told that it would be an independent, sovereign and republic. As well as it will be a union of state but not a federation of state. We will not come into agreement with any provinces. At that time it's a provinces. After independence, we named it as states. We will not come up with any agreement. Nizam told. When the police action was being happened or made on the Nizam of Hyderabad, Nizam of Hyderabad understood that I cannot form a separate country for Hyderabad or I cannot become part of Pakistan. Now there is no escape from India, so there is only one choice to join India. So at that situation, Nizam of Hyderabad had put some conditions to Sardar Vallabhbhai Patel. At that time again Sardar Vallabhbhai Patel had reiterated that India is a union of states but not a federation of states. You cannot put conditions to me. You cannot place conditions to me. So conditions will be made by the center. The conditions will be made by the union. The conditions cannot be made by the provinces. So you have to join Indian Union. USA never, you read any news or if you see movies also. In movies they use the president, American president, but they will not use American Union, they use American Federation only. It's an understanding, it's an agreement. All powers and authority are derived from people. So the power, the authority is derived from the people, means who is supreme? People are supreme. Not a crown is supreme, not a president is supreme. Who are supreme for Indian Union after independence and after the formation of constitution means we are going to derive the power and authority from people of the country. That is the reason in the first sentence, preamble, we the people of India. We made it and we gave it to ourselves. We made it and we gave it to ourselves. So people are sovereign. All people are guaranteed justice, liberty, equality. All people are guaranteed justice, liberty and equality, as well as adequate safeguards shall be provided for minorities, backward and depressed people. Adequate safeguards, constitutional safeguards will be provided to minorities, backward sections and depressed sections. It is present in the objective resolution, so it became part of the constitution. That is the reason Article 29 and 30. That is the reason the reservations for SCs and STs. That is the reason the reservations provided in the Article 358. Means the reservations which are provided or separate provisions which are provided for the depressed classes or backward classes or minorities are present in the Constituent Assembly objective resolution only. So whatever is made in the objective resolution of Constituent Assembly is materialized in the Constitution of India. Maintained the integrity of the territory of Republic and its sovereign rights on land, sea and air according to justice and the law of civilized nations. States shall contribute to promotion of world peace and the welfare of mankind. And the welfare of mankind. This is the objective resolution. No need to remember, but one point you have to remember. So in the objective resolution of the Constituent Assembly, they told that India would be independent, sovereign, republic, and they are going to guarantee justice, equality, fraternity, and India would be a union of state, and the power will be drawn from the people. There is lot of misunderstanding with respect to the terms. So here we used what? Justice, liberty and equality. What is justice? What is liberty? What is equality? First, justice. Justice is fairness. We believe that when we are reading it or when we are try to understand, the justice will be equal to equality only. But justice is fair treatment. Justice is fair treatment. No partiality, no biasness, no partisanship to any community. That is impossible. That is the reason she is blind. So some or the other form of injustice will exist in any society. Why? Because it's humanly impossible to treat everyone equally. So on the day when we are going to treat everyone equally, then they are going to open the eyes of the justice. This is been written by Aristotle. So justice is fair treatment. The fair treatment of people, the quality of being fair or reasonable. So fair treatment, justice means you have to understand everyone should be treated fairly is called as justice. Everyone should be treated with a reason. For example, same like an SC or an ST or an OBC or a general or a EWS, if there is a fair treatment for everyone, it is called as justice. Then what is liberty? Then what is liberty? Liberty means freedom. What type of freedom? Liberties are two varieties. Understand it. So justice means fair treatment. Prelims, statement wise we can expect. Justice is fair treatment. And reasonableness means logical, rational is justice. Liberty, two types of liberties are there, positive liberty, negative liberty. Again, liberty understanding is two types, two varieties of liberties are there, positive liberty and negative liberty. Positive liberty का मतलब क्या होता है? What is positive liberty? What is negative liberty? Positive liberty means absence of restraints, possessing of opportunity, everyone without any discrimination. Then who should provide it? Government. Positive liberty is having opportunities without any restraints. It is called as liberty. Positive type of liberty means it's the responsibility of the government to provide equal opportunities to all, and there should not be any restraints. That is called as positive liberty. Means I can participate in any opportunity without any restraint. That is my liberty. Positive liberty. Government level is called as positive liberty. Negative liberty at individual level. No one can stop me. No one can force me to do something which I don't want to do is called as negative liberty. Individual freedom is called as negative liberty. The freedom which is given by the government for providing equal opportunities is called as positive liberty. The words are very important. So liberty, if they asked only liberty, then we have to tell about the liberty is giving equal opportunities without any restraints and making the individuals to do what they want to do is called as liberty. And at the individual level it is called as negative liberty, and the government level it is called as positive liberty. So negative means not a negative connotation. Negative liberty means at the individual level no one can stop me. No one can stop me if I want to do, or no one can force me which I don't want to do. No one can force me to do which I don't want to do is called as negative liberty. Freedom. Group freedom, individual freedom. Group freedom is called as positive liberty, which is given by government. Individual freedom is negative freedom, which is individual, at individual level. Lot of meaning is there here. Equality. Irrespective of race, irrespective of caste, irrespective of gender, irrespective of religion, equal treatment, equal opportunities, equal conditions. It might be positive conditions or negative conditions, equally. If you beat, equally, equality. If you love, equally, equality. Black color, white color, woman, all are equal, equality, without any bias. Without any bias is called as equality. The situation in which everyone has the same rights and advantages. Everyone have the same rights, everyone have the same advantages. No one is superior, no one is inferior. Equality is about ensuring that every individual has an equal opportunity to make the most of their lives and talents. But liberty, this is provided by the government, then it is liberty. Equal opportunities is provided by the government, that is positive liberty. Generally, if there is using of opportunity, equal opportunities for the growth of the individual is equality. It is also the belief that one should have poorer life chances because of the way they were born. No one should have poorer life chances because of their birth, where they were born, where they come from, what they believe, or whether they have or not. So, where their birth happened, what is their caste, where they come from, what is their belief system, means religion, whatever it may be, there should be equal opportunities. Whatever it may be, there should be equal advantages. Whatever it may be, there should be equal chances. That is called as equality. So, the difference is equality, everyone having equal opportunities is called as equality. Liberty means two types of liberties will be there, which is given by the government, which is individual is possible. At the individual level is called as liberty. Justice is a fair treatment. Justice is from third person point of view. A fair treatment is called as justice. Equality is from the people. Liberty is from the people. Justice is from third party. Justice is a third party, a fair treatment. So, justice can be understood from third party point of view, liberty and equality can be understood from people's point of view. That these three are ensured in the Constituent Assembly as the objective resolutions: equality, justice and liberty. There is a question, sir, is it correct to say absolute freedom is liberty? There is nothing called as, every country doesn't give absolute freedom, absolute equality, absolute liberty, absolute justice. Everything is contained by the constitution of that nation. Everything is restrained by the constitution of that nation. That is a note point. So there is nothing called as absolute freedom, there is nothing called as absolute liberty, there is nothing called as absolute equality. If anything is absolute, it leads to chaos. If anything is absolute, it leads to chaos. So every liberty, every freedom, every justice is qualified. It is qualified. Who is declaring qualified or not? Constitution. Then changes by the Independence Act. What happened? The Independence Act has changed. What they changed? The assembly was made a fully sovereign body, framing any constitution. So after Independence Act of 1947, the Constituent Assembly became sovereign body. Now it is having, the Constituent Assembly is doing two functions. After Indian Independence Act, the same Constituent Assembly which framed or formed in 1946, now it is doing two functions. One function is in making of the constitution, another function is making of the laws. Chattam cheyadam, Rajyangam cheyadam. So what is law? Law making for the running of the country on day-to-day affairs is called as law making. Constitution is something which is a precedent. Creation of precedent for the rule of law of the country is called as constitution. So the Constituent Assembly is having two functions, one is law making, other is constitution. Became a legislative body, thus two functions, making of the constitution and enacting of ordinary laws. Now the same Constituent Assembly is doing two functions, making of ordinary laws for the running of the day-to-day affairs of the nation and for the sake of making of the constitution. Before Independence Act, the Constituent Assembly is having only function which is making of the constitution. After independence, the Constituent Assembly is having the function of making Constitution of India as well as law making. Why law making? For the running of the day-to-day affairs of the nation. As a constituent body, Rajendra Prasad is the chairperson. As a legislative body, Mavalankar is the chairperson. I will tell you. Means the same body. When it is acting like a Constituent Assembly, Rajendra Prasad will come and sit in the chair. The same body, when it is acting like a law-making body, Mavalankar will come and sit as a... So, till independence, Constituent Assembly function was only making of the constitution. After Indian Independence Act, the Constituent Assembly is having two functions, one is making of the constitution, another is law-making. Why law-making? For the ordinary daily functioning, like rules and regulation. Constitution is syllabus of UPSC. Constitution is syllabus of UPSC. Conducting of prelims, conducting of exam centers, selecting of exam centers, conducting of main centers, giving of all tickets, these all are called day-to-day activities. That is called as rules and regulations. So rules and regulations is law and the constitution is syllabus. So the Constituent Assembly is working like a two bodies, one is making of the constitution, other is making of the Muslim League members from Pakistan region. They told that no, we are not going to join the Constituent Assembly. We want independence, and the British also accepted to give the independence. So the number which was 389, complete Pakistan provinces withdrawn from Constituent Assembly. Withdraw from Constituent Assembly, resulting strength from 389 to 299. 90 members of Pakistan provinces, East Pakistan and West Pakistan, these all members withdrawn. So now the Constituent Assembly number became 389 minus 90 is equal to 299. Originally how much? 389. When the Constituent Assembly came into existence, how much? 389. In which 292 from governors provinces and 4 are from chief provinces, 93 seats from princely states. Now what happened? From this 389, 90 members withdrew, saying that we have our own Pakistan Constituent Assembly, now we are not part of Indian Constituent Assembly. So the number is 299. The number is 299. The strength of the Indian provinces, former British provinces, was reduced from 296 to 229 and princely states from 93 to 7. Eventually the Pakistan provinces numbers decreased. Pakistan princely states also decreased. So the number became 299, of which British provinces in India is 229, princely states in British India is 70. So 229 plus 70 is equal to 299. 389 which were been there in the original Constituent Assembly, by the time Indian Independence Act came into existence, 389 became 299 because complete Pakistan withdrawn. At the independence time, what is the number of Constituent Assembly? 299. At the formation of Constituent Assembly, what is the number of Constituent Assembly members? 389. The number of members at the time of Constituent Assembly is 389. The number of Constituent Assembly at the time of Indian Independence Act is 299. Other functions performed, simple facts. 1949 ratified India's membership in Commonwealth. So 1947 we got freedom, but we are dominion status. So still the head of the state is Crown. So there is one particular forum was been opened, a organization was been started which is called a CWG, Commonwealth Countries, CWC, Commonwealth Countries, Commonwealth Groups, CWG. So India want to join this CWG. So the British had ratified it and gave membership in Commonwealth groups in the month of May 1949. July 22 adopted the national flag. January 24 adopted the national anthem and national song. January 24th elected Rajendra Prasad as the first president of India. Remember this date. January 24th, 1950. January 24th. It will come. It had 11 sessions over 2 years, 11 months and 18 days. The complete, it is a long written constitution. 2 years, 11 months, 18 days. Constitution makers undergone 60 countries constitution. Draft constitution considered for 114 days. Total expenditure is 64 lakhs. January 24th, the Constituent Assembly held its final session, but continued all the provisional parliament till formation of new parliament after first election. So, the Constituent Assembly, which is acting like a law-making body, is called as provisional. The Constituent Assembly, which is having two functions. One is making of the constitution, another function is making of the law. So the Constituent Assembly, which is functioning as a making of the law, is called as provisional parliament. So after 1951 elections, the original parliament came into existence. Till 1951, the laws are made by whom? Provisional parliament. What is that provisional parliament? Constituent Assembly, which is acting as a law-making body. So after 1951 election, the first Prime Minister came into existence and first Parliament came into existence. Till 1951, what is the Parliament? Provisional Parliament. What is Provisional Parliament? Constituent Assembly working as an law-making body. So there are some major committees, just not required, knowledge purpose. Union Powers Committee, Jawaharlal Nehru. Union Constitution Committee, Nehru. Provincial Constitution Committee, Sardar Patel. Drafting Committee, Ambedkar. Advisory Committee on Fundamental Rights, Minorities and Tribals and Excluded Areas, Sardar Patel. Rules of Procedure Committee, Rajendra Prasad. States Committee for Negotiations, Nehru. Steering Committee, Rajendra Prasad. You don't remember this, you remember this. This is important. Major committees are important but not minor committees. But constitution point of view, major committees were being like studying. This is studying about union powers, what should be the union powers, what should be the provincial powers. In that way, one committee studied about that and recommended to the Constituent Assembly. Studied that and recommended to the Constituent Assembly. And in the Constituent Assembly, they discussed and they made constitution. Drafting Committee, August 29, 1947, comprised of 7 members. B.R. Ambedkar is the chairperson. These are the members. Gopalaswamy Iyengar, Alladi Krishnaswamy Iyer, Munshi, Syed Muhammad Sadaullah, Madhavarao, T.T. Krishnamachari. Father of Constitution of India, Chief Architect of the Constitution of India and the modern Manu is B.R. Ambedkar. Enactment of the Constitution, first draft of the Constitution published in February 1948, first draft, not final. Draft. Draft means before finalization, when the discussions are happening, is called as draft. Then again it went for discussion for 8 months. Then in the month of October 1948, second draft is placed. After 8 months, second draft was published in October 1948 with public comments. B.R. Ambedkar introduced the final draft on November 4th, 1948. First reading, the second reading, clause by clause, 7653 amendments were proposed. The third reading of the draft November 14, 1949, Ambedkar moved a motion, the constitution as settled by the assembly be. The motion on draft constitution was declared as passed on November 26, 1949. On November 26, 1949 itself, some provisions of the constitution came into force. Complete constitution came into force from January 26, 1950, but some of the provisions came into existence from November 26, 1949 only. Those are important. Why? Because different. What are those? We will discuss. The constitution is adopted on November 26, came into force on January 26. Adopted on November 26, came into force on January. Enforcement. Some provisions. What are those provisions? These are the provisions. Some provisions. These are the provisions. Article 5, citizenship. 6, 4, 5, 6, 7, 8, 9, 10, 11. These 8 articles are citizenship articles. We have to give citizenship, no? Before constitution came into existence only we have to give. Citizenship is mandatory. So on November 26th itself, what are very, very important, those came into existence. Like citizenship. What is 60? 60 is election of president. That is the reason I told you to remember. When the election of the president happened? January 24th, 1950. So before the constitution came into existence, the president is present. Why? Because the presidential election came into force on November 26th, 1949. Because of that only the president election happened in the month January 24th. So before the constitution came into existence, the president was present. Why? Because who should open it? President should open it. So that is the reason the presidential election came into force on November 26th only. Why? It is a current affair now. President election happened. So the election procedure of president came into force on January 26th, 1950 or November 26th, 1949. November 26th, 1949. Because the first president election happened and completed and oath happened on January 24th. Remaining all are transitional, temporary transitional powers. Came into force on November 26, 1940. Citizenship, election of president, temporary provisions of parliament came into existence in November 26, 1940. 3 things. These all are temporary provisions. Elections also. Why elections? President. 324 is what? Election. Election of president. So 324 and 60 both are election of president. So they came into existence on November 26th only. Why? Because then only I can conduct elections for. So elections happened in the month of December. January 24th he took oath. Citizenship, presidential election and temporary provisions of the parliament came into existence before January 26th only. These 3 things. The remaining provisions came into force on January 26th. Date of its commencement, which is called as Republic Day. Purna Swaraj Day celebrations following Lahore Session Resolution of 1929. Why January 26th date? It is because Lahore session of December 1929, we made a resolution that January 26th, 1930 will be called as Purna Swaraj Day. So in order to commemorate the Purna Swaraj Day, we chose January 26th. Not 1929, 1930. 1930, January 26th. But for that the resolution is made in 1929 Indian National Congress meeting. Where that session happened? Lahore. So in Lahore 1929 Indian National Congress session, a resolution was being passed to declare January 26, 1930 as Purna Swaraj Day. So in order to commemorate this Purna Swaraj Day, we chose January 26th. So it is not January 26th Indian National Congress meeting happened. The Indian National Congress meeting happened in 1929 session. But on that day, January 26th, 1930 will be declared as. There is a criticism. For every unit we will do criticism. What is criticism? Criticism on Constituent Assembly. Why? Because making of the Constituent. Making of the Constitution. Who is making the Constitution? Constituent Assembly. Number 1. It is not a representative body. It is not a representative body. Why? Because it is not elected by the people. They all are not elected by the people, they are nominated by some bodies. It is not a representative body as not directly elected by the first criticism. On what? On what? Constituent Assembly. This is a criticism on Constituent Assembly. Not a sovereign body. Why? Who formed this Constituent Assembly? 1946. In 1946, who is the power? British. So it is not made in independent India, it is made in British time. So it is not a sovereign body. Time consuming. They took 2 years, 11 months, 18 days. American Constitution was been made within 4 months. Time consuming. Took only 4 months. Nasiruddin Ahmed called the drafting committee as drifting committee. Drafting committee as drifting committee. Congress domination, only one party we can see. Only one, that is Congress domination. Granville Austin called the Constituent Assembly was one party body in essentially one party country. The Assembly was the Congress and the Congress was India. The Assembly was the Congress and the Congress was India. One party domination. Lawyer politician dominion. Almost all 299 members, 250 are lawyers. The same lawyers became politicians. Lawyer, politician, domination. No other professionals are present in this Constituent Assembly. Dominated by Hindus. Lord Viscount Simon called it as a body of Hindus, and Winston Churchill commented it represented to only one major community in Hindu committee, politician, lawyer committee, drifting committee, not sovereign body, not representative body. These are the criticisms of Constituent Assembly. The demand for a Constituent Assembly was first made by M.N. Roy. M.N. Roy. The demand for a Constituent Assembly was made officially by Indian National Congress for the first time. Year? None of the above. None of the above. 1935. 1935, no, Indian National Congress. Next. Read slowly. Divya, tell me answer. Princely states would veto the resolution passed in the Constituent Assembly. They don't have any veto power. 2 cancelled. Next. Community-based representation was to be abolished in the Constituent Assembly. Was to be abolished or was to be present? Community-based representation should be present. Sikh representatives are there. Muslim representatives are there. This is important. This is one PYQ. I didn't told, but this is a previous year's question. There was a huge debate happened. Huge debate happened in the Constituent Assembly. Whether we have to continue with separate electorate or whether we have to stop with separate electorate. Then what happened? Separate electorate means we are same divide and rule, no? So obviously common sense is separate electorate should be stopped. It's a common sense. Separate electorate will be stopped. Question. The Constituent Assembly deliberated on a number of important issues with many differences. Some people this, some people that. Among the members in their views and ideas, one issue came into existence that is called as continuation of separate electorate for Muslims. Was one such issue. Consider the following statements. Which of the following are correct? Number 1. All the Muslim members of the Constitutional Assembly supported the demand for separate electorate, which was rejected by others. It was Begum Qadsa Aizaz Razul, the lone Muslim woman member of Constituent Assembly, who made a powerful plea for continuing separate electorate. Now you think. The people who asked for separate electorate, the people who asked for separate for Muslims, they went to Pakistan. So already Pakistan got separated. Already Pakistan got separated. When already Pakistan got separated on the lines of religion, why there will be a demand for separate Muslim electorate? If the demand is there, then usually any common man will tell that, then go to Pakistan. Then any common man with a common sense, he will tell that, then you go to Pakistan. Why? Because Pakistan was being formed for separate electorate only, for separate power, for separate government. So you can go and stay. So obviously there is no demand for separate electorate. Number 2, this lady, she is a lady, this lady strongly advocated for removal of separate electorate. All the Muslim Constituent Assembly members strongly advocated for there should not be separate electorate. If we want separate electorate, then we will go to. Means sometimes we have to develop the skill with common sense, with knowledge, we have to put the answer, which is called as intelligent guessing. We will see now answer. B. Pakar Bahadur from Madras made a powerful plea for continuing separate electorate. He is not a Muslim, he is a Parsi. Begum Aiza Rasul, for instance, felt that separate electorates were self-destructive since they isolated the minorities from majority. Means all the Muslims of the Constituent Assembly, Maulana Azad onwards, everyone want to become part of Indian Union as an Indian citizen, not as a Muslim or not as an Hindu. So there is no question of separate electorate debate which was there in Constituent Assembly. But this person, Pakar Bahadur, a Parsi, demanded that let the Muslim continue with separate electorate. Only one person demanded for it. Then everyone criticized him. Are you a Muslim? No. Then why you are asking for it? He kept aside. Salient provisions of Constitution. We think that we know. I am also telling you, 30 minutes I did revision to add something new. For every class I will do 30 minutes revision, or I will add some points and I will come. So that I want to deliver something new. We will think that polity we know, but we don't know. That is a problem with polity. Negative markings, as I told you in the beginning class. Salient provisions of Constitution. These provisions of the Constitution, though borrowed from every constitution of the world, it has several unique features that distinguishes itself from other countries. This will be your conclusion if there is a question that Indian constitution is a ransacking of other constitution, or why Indian constitution is a unique constitution, means yes, we borrowed one or the other provision from all the constitutions of the world, but however our constitution is unique and distinguishes ourselves from others. This will be the conclusion for the answer. What are the salient provisions of Constitution? In original Constitution, salient provisions are there, and with respect to amendments also, the provisions of the constitutions were being changed. The new provisions added, old provisions removed too. So complete, as of today, what are all the salient provisions of the Constitution? So it is not only the salient provisions of the original Constitution, what are all the salient provisions of today's Constitution? 7th Constitutional Amendment Act, 42nd Constitutional Amendment Act, 73rd Constitutional Amendment Act, 74th Constitutional Amendment Act, 97th Constitutional Amendment Act, 101 Constitutional Amendment Act. So the salient provisions were been added to the Constitution, and final salient provisions of the Constitution came into existence. So means what I want to tell, so the salient provisions of the Constitution which I am going to discuss is not the salient provisions of the original Constitution, it is the salient provisions of the Constitutions of today's. So in today's Constitution there is amendments happened. 7th Amendment, I will tell one amendment, one judgments also in the due course of time. 7th Amendment, 42nd Amendment, 44th Amendment, 73rd Amendment, 74th Amendment, 97th Amendment, 101 Amendment. So by this respect to amendments, the constitutional provisions were being added, deleted. For example, right to property was the salient provision of the Constitution in the original Constitution, but it got amended, it got removed. Now right to property is not a salient provision of the Constitution, it is just a legal provision. It is just a legal provision. Like that, deletions happened. Fundamental duties, whether fundamental duties is present in the original Constitution? No. It is added through what? 42nd Amendment. Now it is also part of salient provisions. So today's salient provisions of the Constitution which are present in the original and with respect to amendments. 42nd Constitutional Amendment Act, which is made in the year 1976 in the emergency time, is called as mini constitution. The major provisions of the constitutions were being changed by Indira Gandhi. Then again, respond to the 42nd Constitutional Amendment Act, 44th Constitutional Amendment Act, again reversed what are all the amendments which are made by Indira Gandhi. In 1978, by Janata government, you understand this. Jawaharlal Nehru, then Lal Bahadur Shastri, then Morarji Desai, then Indira Gandhi. Indira Gandhi continued from 1969 onwards. 1971 elections, midterm elections, 1971 elections, she got a trumpet victory. 1971. 1975, the elections should conduct. But in 1975, because of internal disturbances, the emergency was been applied across India. So, when emergency is there, 1 year the parliament will be extended. So, from 1975 to 1976 the parliament got extended, but emergency did not came to an end. Again 1 year extended, 1976 to 1977. 1977 the emergency stopped and elections happened, and in 1977 November month Janta government came into existence. So, in this time period in 1976 what Indira Gandhi did? She made a constitutional amendment, Rajyanga Savarana. She made a constitutional amendment. In that constitutional amendment, she added all those points which are beneficial to her. So, again when Janta government came into power, they reversed what are all the amendments made by the Indira Gandhi. So, Indira Gandhi's amendments are called as 42nd. Major provisions of the constitutions were being removed, hence called as mini constitution. But again 44th Constitutional Amendment Act, what are all the constitutional amendments were being made with respect to salient provisions of the constitution will be reinstalled by 44th Amendment. Why she made the amendments? In 1973, a judgment came on April 24th, which is called as Keshavananda Bharati case. In that Keshavananda Bharati case, the Supreme Court told that there are some basic provisions for the constitution, there are some basic characteristics of the constitution, there are some basic features of the constitution which cannot be amended by the parliament. So, she got angry, and in order to control this, she made an amendment which is called as parliament have all the powers to amend anything, including fundamental rights also. Why? Because in that they told that fundamental rights are basic structure. So, these all are reversed by which Constitutional Amendment Act? 44th. I will one unit is there, basic structure doctrine. But as of now, so what is the takeaway is? The takeaway is, so the salient provisions of the constitution is not the salient provisions of the original constitution. The salient provisions of the Supreme Court ruled that the constituent power of parliament under Article 368 does not enable it to alter basic structure of the constitution, and it told that basic structure is fundamental rights. And in the Constitutional Amendment Act, the Constitutional Amendment Act, the Indira Gandhi told that no, parliament can amend anything including fundamental rights. So, what are the salient provisions of the constitution? Number 1, lengthiest written constitution. Lengthiest written constitution. Why? Because they took 2 years, 11 months, 18 months, then obviously it should be lengthiest. By taking this much and writing only one paper means, so as they took time, it should be very lengthy. Lengthiest written constitution. Original constitution, 395 articles, 22 parts and 8 schedules. Present, 470 articles, 25 parts and 12 schedules. 4 factors for elephantine size. Why this much big, lengthiest written constitution is required? Because of geographical diversity. Northeastern people are there, Himalayas are there, Jammu and Kashmir is there, Thar Desert is there, Western Ghats is there, geographical diversity. Different sections of people are there. So, because of geographical diversity, there is a more provisions need to be added. So, one is geographical vastness. Historical. Already we have a Government of India Act of 1935 that itself is a bulky, and we copied 50% from Government of India Act. So, that is bulky, so this is also will be bulky. We have single constitution. America have 2 constitutions. One is a federal constitution, other is a state constitution. But in India we don't have state constitution. So, state provisions are also part of original constitution. So, there will be lengthiest written constitution. First is geographical vastness. Number 2 is historically we took from Government of India Act of 1935, which is already a bulkier. Number 3 is single constitution. And the 4th is dominance of legal law. They started using the words. The lawyer words, the constitutional words, the legal words. So, obviously the document will become very big. Dominance of legal luminaries. Prelims point of view, what are all the factors which are responsible for making the constitution? Lengthiest written constitution is geographical vastness, historical Government of India Act of 1935, single constitution, dominance of, this is very important. Next, drawn from various constitutions of the world. Drawn from various constitutions of the world. From where what? We copied from where? What? Ambedkar quoted, Constitution of India has been framed after ransacking of all the known constitutions of the world. I made a final note, summary notes by looking into all the sources. So this would be the best notes. Ransacking of all the known constitutions of the world. The most influential material source of our constitution is, first big is Government of India Act of 1935. Major part of Government of India Act of 1935 is taken into original constitution. Second, Weimar Constitution, emergency provisions. Weimar Constitution means German Constitution. Weimar Constitution means German Constitution. Japan, procedure established by the law. Procedure established by law. Procedure which need to be followed. Procedure which need to be followed. Procedure established by law. French, Republic and ideals of liberty, equality and fraternity. Liberty I told, equality I told, fraternity means brotherly feeling. Brotherly feeling between the citizens of the country is fraternity. So fraternity, equality, liberty and republic taken from French. South Africa, procedure for amendment and election of members to Rajya Sabha. Constitutional amendment procedure and election to the members of Rajya Sabha. From where? South Africa. From where? South Africa. USSR, fundamental duties and ideals of justice, political, economical and social. Social, economical and political. Drawn from USSR, not Russia, USSR. USSR at that time we took from USSR. Australia, congruent list, freedom of trade, commerce and intercourse and joint sitting of the two houses. When the bill is not passing in either house of the parliament, then the president have the power to summon both the houses and the presiding officer will be the speaker of Lok Sabha. So joint sitting sessions is borrowed from Australia. Congruent list, Australia. Trade and commerce, Australia. Procedure established by law, we will see. From where what we took. Government of India Act, All India Federation, Federal Scheme, Office of Governor, Judiciary, Public Service Commission, Emergency Provisions, Administrative Details. From Government of India Act of 1935. All India Federation. No, I will tell you. Government of India Act of 1935. Federal Scheme, Office of Governor, Judiciary, Public Service Commission, Emergency Provisions, Administrative Details. See here. This emergency provision is suspension of fundamental rights at the time of emergency is this emergency provision. Suspension of fundamental rights at the time of emergency is this emergency provision. That is complete emergency provision. British, parliamentary form of government. Writs, legislative procedure, the law-making procedure, single citizenship. British also single citizenship, India is also single citizenship. Cabinet system, they also have the cabinet system, portfolio system, India also have the cabinet system and portfolio system. Rule of law. Sir, what is this rule of law? I will tell you, see. Rule of law means everything according to the rules is called as rule of law. In this example, in that one, the best example is procedure established by law, which we taken from Japan. What is procedure established by law? Example of rule of law is procedure established by law. Means with rule of law and procedure established law is also present in British. Yes or no? In America, there is due process of law. In America, there is due process of law. Due process of law and procedure established by law. These both are in conflict. These both are different. Procedure established by law is an example of rule of law. Means procedure like this. You have to get down steps, first floor, down ground floor, then you will go on the road. That is called as procedure established by law. A clear-cut procedure. So what happened? Mavalankar, with his team of constituent assembly members, they went to America. When they are getting information, which provisions we have to adopt. And they sat with the Supreme Court judge of America. And the Supreme Court judge of America told that the Supreme Court judge of America had discussed, and he informed that we follow due process of law. But you are India, you are a newborn country. There is a lot of discretion will be there of the judges. There will be lot of discretion will be there if there is due process of law. Due process of law means natural justice. So how I look might be different from what you look. For example, in self-defense, if one person kill, for me it might be, yes, in self-defense he killed, no problem. In another person's issue, it's okay, self-defense you are fighting, but you didn't fight, you directly killed him. So interpretations will change, discretion will change, it might be detrimental to a newborn country like. So American judge told that it might be suitable to the civilized countries or who had enough experience, who have enough experience of judiciary, who have enough experience of constitutional provisions, for them it will be suitable like America, but not for, because you are a diversified country. You are having diversity. Muslims are there, Hindus are there, Christians are there, different languages are there, different castes are there. So interpretations will vary. Your country is not homogeneous country. If homogeneous country, you can have due process of law. Why? Because everyone thought process will be same. But your country is diversity. So your thought process, another thought process might not match. Hence there will be a conflict. So better you go with. That is the reason we came up with procedure established by law, but not due process of law. America follow due process of law. In India, procedure established. He came to kill you. So you killed. You killed. Section 305, you killed means murder, finish. Put him inside the jail. Procedure established by the law. America, oh, in self-defense, you killed. It's a natural justice. You can do it. No punishment. Due process of law. But in India, we have due process of law only in National Green Tribunal. We follow due process of law only in NGT. National Green Tribunals. Tribunals follow natural justice. There is no procedure established by law. It is according to the due process of law. Means according to the discretion of the judge, basing on instincts, natural instincts. But procedure established by law, civil procedure code, criminal procedure code, rule of law, Indian judicature completely is procedure established. But tribunals is due process of law. So this one, rule of law, rule of parliamentary privileges. Why? Because parliament, we borrowed parliamentary system from British. USA, independent judiciary. Judiciary will be independent. India also independent. Fundamental rights, Bill of Rights, judicial review from America, president impeachment from America, removal of Supreme Court judges and High Court judges from America, post of Vice President from America. Irish, directive principles of state policy, we borrowed from Irish. But it is also there in Government of India Act of 1935 by the name called as Instrument of Instructions. It is also there in Government of India Act of 1935, Instrument of Instructions. But then why I used Irish? What are all present in the Government of India Act of 1935? Almost 70% are deleted, only few are taken. Most of them are from Irish. So the DPSP is borrowed from Irish and Government of India, but most of the provisions of DPSP are borrowed from nomination of members to Rajya Sabha. Election of members to Rajya Sabha from election of the members of Rajya Sabha by method of election of president. Method of election of president. Federation with strong center, quasi-federal. Federation with strong center, quasi-federal from Canada. Appointment of state governors by center. Residual powers, which is not present in the concurrent list, which is not present in the Shravani. Then how can we say we adopted from Australia? It is from 1935. All India Federation. It is there in Government of India of 1935, whereby there is a federal list, provincial list and concurrent list. Whether it came into existence, whether it is operational, All India Federation came into existence, Government of India Act of 1935. So that means it was there but not adopted. It is there. So it is from, it was written only but never came into operation. It was operation. So it was operation, it was successful, so we borrowed from Australia. Which one? Congruent list. Residual powers, which is not there in the union list, which is not there in the state list, which is not there in the provincial list, that is called as residual powers, which is nowhere. For example, in 1950, cyber security is there, cyber crimes are there, then who should make law on cyber security? In 1950, whether cyber crimes are there? No. Now cyber crimes are there. Then who should make the law? Confusion. Those things which are not present in these three lists are called as residual. Borrowed from Canada. Center will be having the power. Center will be having the power. Borrowed from Canada. And last, advisory jurisdiction of Supreme Court. The government have the power to take the advices from the Supreme Court. Advisory jurisdiction of Supreme Court taken from Canada. Weimar Constitution, complete emergency provisions. Why Weimar? Because it's Hitler's at the time. Hitler Constitution. Japan, procedure established by law. French, Republic of Ideals, liberty, equality and fraternity. South Africa, procedure for amendment of the constitution and election of members to Rajya Sabha. USSR, fundamental duties and ideals of justice, social, economical and political. Australia, congruent list, freedom of trade, commerce, intercourse and joint sitting. Government of India, federal scheme. Federal scheme didn't came into operational, but the idea was good, so directly they took whatever is there in the Government of India Act of 1935. Federal scheme, Office of Governor, Judiciary, Public Service Commission as it is, emergency provisions mainly with respect to suspension of fundamental rights, administrative details, administration, IAS officers, administrative details taken from Government of India Act of 1935. British, parliamentary system, prerogative writs, bicameralism, 2 houses, legislative procedure, 2 houses should pass the bill, single citizenship like British, cabinet system, rule of law, parliamentary privileges. This side, DPSP, Irish, most of the provisions, nomination of members to Rajya Sabha, method of election of president, Canada, federation with strong center, appointment of state governors by the center, residual powers, advisory jurisdiction of. These are the main provisions of Government of India Act, British, US, Irish and Canada. If you understand or remember, salient provisions of the Constitution, 50% of polity completed. Everything is just provisions only. What is the first one? Lengthiest written Constitution. Number 2, drawn from various sources. Number 3, blend of rigidity and flexibility. What is rigidity and flexibility? I will tell you. It's both. Constitution is rigid and flexible as well. Why flexible? I can amend the Constitution, so flexibility. I am not telling that the Constitution cannot be amended. I am telling that Constitution can be amended, so flexibility is there. But while amending, the procedure is very much rigid. How? Special majority. Independently, individually, the bill need to be passed in Lok Sabha, Rajya Sabha with special majority. What is special majority? Understand. For example, 100 members are there. Compulsory minimum attendance should be 50% of the house. Minimum attendance should be 50% of the house, and the number of people who are present and voting in that, the number should cross 2/3. If 100 members are there, compulsory attendance should be 51 and more. If not less than 50 members attendance, I cannot go for special majority voting. So for voting itself, the majority should be present. Majority means 50% should be present. When 50% should be present, it should be more than 50%. How much number it may be? First condition is minimum 50% should be present. 50% are present. Then the people present and voting should be more than 2/3. For example, 100 members, 60 members came. Yes, I can go for voting. Why? Because it's more than 50%. 60. 2/3 means how much should vote for it? 40. More than 40. 41 should vote for it. Then special majority. So special majority, first condition, the number of people present and voting should be more than 50% of the house, and the number of people present and voting should cross 2/3 of the members. 2/3 of the members. Independently Lok Sabha, independently Rajya Sabha. Very complex. Not only that, if that amendment is disturbing the federal feature, then 50% of the state assembly should give its approval, ratification. Then only the constitution is getting amended. So I can amend the constitution, so flexibility is there. When I am going to amend, the procedure is rigid constitution, special procedure for amendment taken from America. Flexible constitution is same as ordinary laws made of British. Indian constitution is blend of both rigidity and flexibility. Article 368, some provisions special majority of the parliament, 2/3 majority, some other provisions special majority plus ratification by half of the state assemblies. Why I am telling flexible? I can amend. Possibility is there, so flexible. When the possibility is there, I started. But when I started, it is rigid. Why? Because the procedure is very complex. So it's a combination of rigidity and federal system with unitary bias. Today I gave the notes, PDFs I provided. Making of the constitution, salient provisions of the constitution, preamble, and union and the territories. Union and the territories notes provided. Federal system with unitary bias. Our Indian constitution did not told, it did not give clarity. Ours is unitary or federal. It's a union of states, not unitary, union of states, combination of states. Combination of states means it's an understanding between the states. So whether union is powerful or state is powerful, whether the union government is sole authority or the state government is sole authority, two are there. Union government is there, state government. So federal features with unitary bias. So state government is also there, central government is also there, police is under state government, defense is under central government, both are powerful, but when there is a conflict between both of them, only central will prevail. When there is conflict between both of them, only central will prevail, hence we call it as federal features with unitary bias. Federal features, two governments are there, two division of powers are there, union list, state list, concurrent list. Written, everything is written, so clarity is there. Central government is having powers on what? State government is having powers on what? Why? Because it is written. So I cannot manipulate. Why? Because everything is written. Supremacy of the constitution. Parliament is not supreme, Supreme Court is not supreme. What is supreme? Constitution itself is supreme. Rigidity of constitution. This constitution you cannot amend. Why? Because it's rigid constitution. So federal features are promised, ensured. Independent judiciary. So judiciary will act according to the constitution. It will not blend for central government or not bend for state government. Independent judiciary also ensures what? Federal features. A union government, what you are doing? It is the power of state government. So judiciary will not fear for central government. Judiciary will not fear for. So then only they can be independent. So that independent judiciary is good for protecting. Any question? How we can ensure federal features? How we can ensure federation of the country? How to protect the federal features of the country? This all. Number one, two governments are there, proper division of power is there, written constitution is there, supremacy of the constitution is there, rigid constitution is there, independent judiciary is there, and again why bicameralism? Two houses. One house is called as House of People, directly elected by the people, but another house is Council of States. Whose representatives are present in Rajya Sabha? State representatives are there. Then states, they will discuss in the Rajya Sabha. You people are taking the powers of states. So a separate house is there. In that separate house, any bill which is placed in the parliament, it is passed in the Lok Sabha, but it will not pass in the Rajya Sabha. Why? Because state representatives are present. They know that this bill is going to cut the powers of state, so they will not pass the. So by these provisions, I can tell that yes, Indian constitution is a federation. However, unitary also. A strong center. When there is a conflict between the center and the state, who's prevail? Center. Strong center. One constitution or two constitutions? One constitution. Single constitution. One citizenship or two citizenship? Single citizenship. But in America? Multiple constitutions. Every state have their own constitution and a federal constitution. Multiple citizenship. Every state have their own citizenship and country is also having federal citizenship. Single citizenship. Flexibility of constitution, I can amend. So there is a chance that the federal features can be removed by flexibility of the constitution, and I can make it as a unitary. That chance is also there. Integrated judiciary, High Court, Supreme Court. High Court, Supreme Court. High Court, Supreme Court means if any judgment which is coming from High Court will be heard in Supreme Court. So integrated judiciary is going to Delhi. Delhi is unitary. Delhi is unitary. So integrated judiciary is also one factor which is ensuring unitary constitution or unitary features. Appointment of state governor. Governor is an agent of central government, or the governor is a independent person. So unitary. By the center. All India services, IAS, IPS, Indian Forest Service officers, they are recruited by which government? Central government. But they are posted where? In the state. So when my worker, my servant is recruited by me, I post them, then he should listen to state government or central government. Emergency provisions. In emergency provisions, everything is under the control of center. So these are the federal features, these are the unitary features. These are the federal features, these are the unitary features. So because both are present, I am telling that federal system with unitary bias. As both are present, federal features with unitary bias. Term federation is nowhere used in our constitution. It is used union of states. It is just used as union of states. Nowhere it is used. Article 1 describes India as a union of states, which implies two things. One, Indian federation is not the result of an agreement by the states, and two, no state has the right to secede from the federation. Why? Because we didn't came with agreement. So we are together, we have to stay together. The meaning is we are together and we have to stay together. There is no chance that you can divide from me. But if it's a bond, if it's an agreement, America, anytime they can be broken into pieces, anytime they can be divided into pieces. Why? Because it's an agreement. But India is union of states. Indian constitution, federal in form, but unitary in spirit. Quasi-federal, K.C. Ware, constitutional expert. Bargaining federalism, Morris Jones, and cooperative federalism, Granivelli Austin. This type of sentences are important. See, listen. We will discuss, tomorrow only we will discuss 2022 GS2 question paper polity questions. Then you will understand what type of questions they are asking in mains. Compulsory one question will be there on federalism. Compulsory. Why? Because being an IAS aspirant, you should know federalism or center-state relations. In center-state relations, in federalism, governor role is important. Any question. Now, federation is nowhere written, but federation is important. Federation is important or unitary is important? Federation is important. Why? Because local government, decentralized government, decentralization is important. Unitary government means centralization, like medieval India, like Akbar, like Mughal dynasty, everything power is vested in one person or one government. No. Power should be decentralized. So the federation is important. Why? Because in federation there is division of powers between the center and state. So we have to promote a federation. So what type of federation? Cooperative federation, bargaining federation, integrative federation. Central government is not boss to the state government. Both are bosses. I am also people's representative. You are also people's representative. I am chief minister. You are prime minister. But for my people, I am the representative. For the large number of people, you are we both are equals. Prime minister and chief minister are equals from the point of view of people, not from the point of constitutional precedence. I am talking from the point of view of people. So federation is required. When grassroots level government is there, people can approach the government quickly. If I want to go for everything to Delhi, it's a very Herculean task. I can go to Hyderabad or I can go to Mumbai if I am from Maharashtra. So we have to promote, in any answer, we have to promote federation. We should not promote unitary. Tell me quickly, what are the federal features? Federal features, number one, division of powers. Written constitution. Next, supremacy of the constitution. Rigidity of the constitution, yes. Independent judiciary, next. Bicameralism. Unitary features. Strong center. Flexibility, flexible constitution, next. Single constitution, single citizenship, all India services, emergency provision, appointment of governor by the center. These all are. So, we are not unitary, we are not a federation, we are federal in nature with unitary bias. If more federation also problem, what is the problem is, there is a chance that there might be a demand for separation. So, in order to stop that separatist tendencies, we are telling that federal features with. Yes, Pranay. Sir, if a country has constitution, does this need to be supreme in that territory? Yes. Because we have written constitution which is supreme, unlike United Kingdom, despite of having constitution, House of Lords is sovereign. See, listen. British doesn't have written constitution. What is written constitution? Written constitution means everything is in one book. If everything is in clear-cut one book, it is called as written constitution. Britain, it is unwritten constitution. Constitution is there, but it is unwritten. Sir, what is unwritten or uncodified? In India, it is called as written and codified constitution. Codified is nothing but everything is amalgamated together. Everything is integrated together in one book is called as written constitution or codified constitution. UK have the constitution, but it is not written constitution. Means what? Parliament is supreme. Parliament, whatever they make the law, those all laws are constitutional laws. But they are not present together as a one book. Because of which we will tell it as an unwritten constitution or uncodified constitution. But it is a. So their supremacy is, the difference is, there the supremacy is parliament. Why? Because parliament is making the constitution. So the parliament can make a new points or remove the old points and give a new points. But in India, constitution is supreme, by which we are telling that the parliament is not supreme, constitution is supreme. The parliament, while making the law, they have to take care that whether the constitution provisions they are following it or. Parliamentary form of government is also a unique feature of Indian constitution. Parliamentary form of government, based on cooperation between legislature and executive. I will tell you, listen. State is divided into three powers, three arms. Legislature duty is to make laws. Executive duty is implement the laws. Judiciary rule is whether the executive is implementing according to the provisions of laws or not. Checking is judiciary. Supervision is judiciary. Implementation is executive. What is parliamentary form of government? We have parliamentary form of system. What is parliamentary form of system? Parliamentary form of system is legislature itself is executive. Narendra Modi is first a legislature or a executive. First he should become an MP. Then MP can be chosen as a prime minister. So first I become an MP means first I am an legislature. First if I become a legislature, then I will be qualified to be called as a minister or else prime minister. What is executive? Council of ministers headed by prime minister is called as executive. What is executive? Council of ministers headed by prime minister is called as executive. Who are legislatures? Member of parliament are called as legislatures. So if I want to become a council of minister, if I want to become a prime minister, first I should be elected as an MP. So first I should be a legislature. If I am a legislature, then only I can become a executive. Okay, some other points are there. Up to 6 months, if he is not a legislature also, he can become, but one time or the other, he should be a legislature, no? So legislature only can become a executive. But in America, legislature is separate and executive is separate. President is separate and secretaries are separate. Legislatures are separate and executive is separate. In India, India adopted for a British parliamentary form of government, also known as Westminster form, establishing parliamentary system both in center and state. Difference: India elected head republic, Britain hereditary head constitutional monarchy. Indian parliament is not sovereign body like British. Similarity: prime minister performs crucial role, hence prime ministerial form of government. Mainly we have to understand it's a cooperation between legislature and a legislature only can become a executive. Ours is not American form of parliamentary system. Ours is British form of parliamentary system or Westminster form of parliamentary system. What is Westminster? A road on which the parliament of the British is present. So it is Westminster form of government or parliamentary form of government. So first to become part of government or first to become an executive, I have to become. So it's a cooperation between the legislature and executive. India is elected head, so republic. Britain is constitutional monarch, so it is not republic. Britain is not republic, we are republic. Features of parliamentary presence of nominal and real executive. There is a nominal executive and real executive. Who is nominal executive? President. Who is the real executive? Prime Minister. This Prime Minister first a legislature, then only he can become a executive. Majority party rule in the legislature, who is having the majority, they will only form the executive. So the relationship is there. But in America, there is no relationship between the executive and legislature. The election for legislature will be separate, the election for president will be separate. In India, both election is one and the same. First I should become the legislature, then the majority party of that legislature will form the government, and then that political party will select the executive. That political party will select the executive. So only one election for legislature and executive, but for their separate election for legislature and executive. Collective responsibility of executive to legislature. No confidence motion on the executive. Complete executive will be collapsed. So it's a collective responsibility, not individual responsibility. In America, if there is any no confidence motion, it will be only on the president. If there is an impeachment procedure, there will be only on president. There is no confidence motion in America. I am telling, just if I want to remove the government, who is the government? President is the government. Then I have to go for impeachment, individual level. But in India, if I want to remove the government, it's a collective level. Complete government, I will go for no confidence motion. Collective responsibility is there in India. That is a unique feature of parliamentary form of government. The presidential form of government, if the president is a fool, then the country will become the fool. Leadership of prime minister or chief minister. Dissolution of lower house. If once the lower house is legislature or executive. Once the lower house is dissolved, then the government also will be dissolved. For example, what happened? KCR in 2018 dissolved assembly, legislative assembly of Telangana government 1 year earlier, 2019, but he dissolved 1 year earlier. When he dissolved the assembly, lower house, then the government also will collapse. So if legislation is not there, means executive also will not be there. That type of system is called as parliamentary form of government. It is a cooperation between legislature and executive. Synthesis of parliamentary sovereignty and judicial supremacy. I will tell you. Parliamentary sovereignty. Parliament have the power to make any law according to the provisions of the constitution. So yes, parliament is sovereign, but it should be according to the provisions of constitution. But judiciary is supreme. Final interpretator is who? Final interpretator of the constitution, final interpretator of the law is whatever the law made by the parliament will be interpreted by judiciary, means judicial supremacy. If I am interpreting and I am giving the judgment, I am supreme. Judiciary, judicial supremacy and parliamentary sovereignty. So parliament is having the powers, I will tell you. In Britain, parliament is sovereign. Granively Austin told, why? Because there is no written constitution in Britain. Granively Austin told the parliament is so much sovereign in Britain that they can do anything. Just a man, a woman, a man. If not that, they can do anything. Means parliament is sovereign, super powerful. But in India, parliament is sovereign but limited by constitution. Within the limits of constitution we have to do after 1973. Before that, parliament is also having the power to make anything. But after 1973 it is limited that parliament can do any law within the limits of constitution. The doctrine of sovereignty of parliament, British parliament, well, the principle of judicial supremacy, American Supreme Court. In America, judicial supremacy. Why? Because everything is interpreted by Judiciary. So we borrowed parliamentary sovereignty from Britain and we borrowed judicial supremacy from America, and we are following both. We have parliamentary sovereignty as well as American constitution provides due process of law, but Indian constitution procedure established by law. The Supreme Court on the one hand can declare the parliamentary laws as unconstitutional, means parliament judiciary supremacy through the power of judicial review. The parliament on the other hand can amend the major portion of the constitution through its constituent power. Major provision I told, not all. Major provision I can do, but not all. Why? Because some are basic structure. So there is a parliamentary sovereignty and judicial sovereignty. How we can ensure parliamentary sovereignty and judicial supremacy? We have tried. The basic feature, one of the basic feature of the Indian constitution is parliamentary sovereignty and judicial supremacy, which we borrowed from America, judicial supremacy, and from Britain, parliamentary sovereignty. The British parliament is having all the powers. They can make any law and they can make any law repealed. But in India, yes, we can make any law or we can repeal any law till 1973, but after 1973, we can amend a major part of the constitution. So as we can amend the major part of the constitution, it is parliamentary sovereignty. But however, it is finally interpreted by the judiciary. Hence, there is a judicial supremacy as well. So it's a synthesis between parliamentary sovereignty and judicial supremacy. I am taking huge time. Why? Because this is conceptual clarity. Oh, this is what parliamentary sovereignty means. This is what judicial supremacy means. Judiciary is supreme because they are if I am interpreting you and I am judging you and you are following, it means I am supreme only. I am sovereign. I can make any law. Means I am sovereign. Sovereign is super powerful. Tomorrow we will discuss about integrated and independent judiciary. Integrated and independent judiciary. Everyone stay 1 minute, don't go. Integrated and independent judiciary. This will complete. Integrated, lower court, high court, Supreme Court. If one judgment is out from the Supreme Court, it will become a precedent for all the courts. Integrated. Independent, they will follow rule of law. They will not bend for central government or state government, they are independent. So the next provision is integrated and independent judiciary. Lower court, high court, Supreme Court. In America, federal laws enforced by federal judiciary, state laws enforced by state judiciary. But in India, Supreme Court can also enforce state government laws, central government laws. Means in state legislation, if state legislature, state assembly, any law is there, who can interpret it? High Court can interpret as well as Supreme Court also can interpret. But in America, federal court can interpret only federal laws. State Supreme Court can interpret only state laws. But in India, Supreme Court can interpret central laws as well as state, integrated. In India, single system of court enforces both central and state laws. System of courts, Supreme Court, High Court, subordinate courts. Provisions ensuring independence, security of tenure of judges, independent. I am appointed. I can be removed only by impeachment procedure. That impeachment procedure is complex, which I will tell you later. But I can be removed only by an impeachment procedure, not according to the discretion of Narendra Modi or not according to the discretion of Draupadi Murmu. So, whether I will be confident or not, whether I will act independently or not, now no, you cannot remove me, man. You cannot threaten me. I will act according to my independent decisions. So, independence of the Supreme Court is ensured by security of tenure. You cannot remove me, then I can act, no. Fixed service condition. What are all my jobs? Which is already fixed in the parliamentary law. You cannot change it. For example, if I am your employee, then what you will do? If you don't like me, you will give new work to me. So then what I will do? This person will give all works. I will be good to him. Yes boss, I will tell. Then he will not give me any work. If fixed service conditions are there, I no need to worry. Why? Because the service conditions are fixed by the parliamentary law. So I can act independent. Security of tenure of the judges, fixed service conditions for the judges. Money, the salary is not given by the central government. The salary is drawn from the consolidated fund of India. So there will be a very big fund. From every month they will be getting salary from the fund automatically. So whether I will be listening to the person who will be paying me the tax, or I will be independent when I am taking tax salary from a box, from a separate box. When I am taking salary from a separate box, I no need to worry for anyone. But if anyone is paying me salary, then obviously I will be loyal to him. When I am being loyal means I will not be independent. So first is security of tenure, second is service conditions, third is all the expenses of the Supreme Court will be charged on the consolidated fund, means directly I can draw from the consolidated fund. Prohibition or discussion on the conduct of the judges. For example, you are there, I will talk backward, hey, this person is like this, then automatically we will be influenced. Everyone are criticizing about me, I will not give this judgment. If I give this judgment, everyone will talk behind me about me badly, negatively, then I will not give judgment. No one should talk about me outside. No one should talk about my judgments outside. So what? I will not have any pressure on me. I will not have any moral pressure on me. So what? I will give my judgment independently. Prohibition or discussion on the conduct of the judges in the legislatures, mainly in the legislature. Ban on practice after retirement. You give judgment, after your retirement I will give you one contract. Okay, what judgment I have to give? So there is a complete ban after retirement. So what will happen? It will be independent. No practice after retirement. Ban on all government jobs after contract. Ban on all government contracts after retirement. So you cannot lure me. So I will act. Anyhow, only 6 months are there. I will get pension. You give or not, I will give this judgment. So I will be independent. Power to punish for its contempt vested in the Supreme Court. If someone is talking about me, I will give punishment. So that person will be feared, so that he will not talk about me or he will not criticize me. So I can act independently. Finally, separation of the judiciary from the executive. Executive have no role in the judiciary. So judiciary can act independently. These are ensuring what? Independence of judiciary. What is integrated? Lower court, high court and Supreme Court. Integrated judiciary and independent judiciary. Tomorrow we will discuss about fundamental rights. Tomorrow, fundamental rights, directive principles of state policy, fundamental duties, and 2022 question paper also we will do. Secular state, universal adult franchise, single citizenship, independent bodies, emergency provisions. What are the emergency provisions? 3 types of emergencies. 3-tier government. What are 3-tier government? Gram Panchayat level, Mandal level, district level, village level, Mandal level and district level. Then cooperative societies. These are the 17 salient provisions of Constitution. Number 1, lengthiest written Constitution. Number 2, drawn from various sources. Sir, Randy sir, Chaitanya sir, come. So Chaitanya sir is your mentor. He will be there and I will be there, both. If you write any answers, because the Super 50 batch is very important for us, it's a very strategic batch, we are very serious about it, and we try our best to give best and to get best from you. So sir went to UPSC interview 3 times, is a very senior faculty also, but here he will be helping all you people with me. You can contact Chaitanya sir, you can contact me. There is another madam, Sindhu madam and Kranti sir. Mainly Chaitanya sir and me, we are every time we are available in the academy. Any doubts, anything, we will be sharing Chaitanya sir phone number also, my phone number also into the Telegram channel. So our main motto is your 2023 prelims. We will try from our side, you also try. For 2023 clearing prelims. If prelims is cleared, I am telling you, every day properly we will do and we will clear the mains also. So so sir will be helping you. Sir number we will be posting in the Telegram channel. Okay.
Okay guys, all the best. Do well. Write your exams daily. Okay. Take care.
Thanks. So these are the 17 salient provisions of Constitution. We will meet tomorrow. Thank you. Today's question: why Indian Constitution? No, this we asked. Yes. Why Indian judiciary is called? Why Indian judiciary is called? Why Indian judiciary is called integrated and independent judiciary? Integrated and independent judiciary. Question mark. What is the meaning of judicial supremacy? What is the meaning of judicial supremacy? 10 marker, 150 words, 2 pages. Remember this. 150 words means 2 pages. 200 words means 3 pages. 250 words means 4 pages. Again, no need to count the numbers. 2 pages means 2 pages you have to fill. If you fill 2 pages, it means default 150 words. 200 words means 3 pages. If you fill 3 pages, it is called as 200 words, not counting. You have to fill 3 pages, you have to fill 2 pages, you have to fill 4 pages. Why Indian judiciary is called as integrated and independent judiciary? Question mark. What is the meaning of judicial supremacy? 10 marker, 2 pages, 150 words. Thank you.